Good afternoon and welcome to Your Trust, Your Pet, and Your Legacy. Thank you all for taking time out of your day to learn more about a topic that is important to all of us. I'm Mia Dunn and I'm the Senior Director of Philanthropy at Pasadena Humane. I will speak a little bit later about the benefits of naming Pasadena Humane in your estate plan if you're so inclined to do that, to make such a gift that will have a lasting impact on the animals in our care. Now I would like to introduce today our presenter for today, William Hayes. Bill is originally from Chicago and moved to Los Angeles as a young boy. His first dog was a brindle boxer named Duke, who was adopted from a local shelter. Bill graduated from the UCLA School of Law, where he served as senior editor of the UCLA Law Review. And among the many hats he's worn then and since are as member, editor, and grader of the UCLA Moot Court Honors Program, associate editor-in-chief of the National Law Journal, a syndicated newspaper columnist on estate planning topics, a contributing author to several books on estate planning, and of course, he's the founder of the Hayes Law Firm in South Pasadena, where he handles estate and business planning. Bill is currently a member of the American Academy of Estate Planning Attorneys and the Estate Planning Council of San Gabriel Valley, among other groups. Outside of the field of law, Bill has tried his hand at comedy, studied stained glass design, traveled extensively, plays the flute, and has practiced martial arts for 20 years, earning his black belt. Prior to founding the Hayes Law Firm, Bill was a lawyer in the film and music industry. So thank you very much, Bill.
Thank you, Mia. Okay. Thank you, everyone. Thank you for being here. And of course, today we're going to talk about not only estate planning, but planning specifically for your pets. Okay, it's not working. Oh. I think we have a technical problem here. Mia, I have to step away and bring the technical person in.
No worries, Bill.
Okay.
And to our attendees, thank you for your patience. Even after 3.5 years of Zoom, there's still bugs in the system.
There's still bugs in the system. Okay, I think he's going to get something else. Okay. Got it.
I'll just tap that.
Okay. Okay, I think we're back on. On the screen, you'll see a little bit about my background. He has told you a few things, and here are some other things more related to the practice of law. We have been cited by most of the major media as a source of information for elder law and estate planning issues. Our office has been located for the last 24 years in South Pasadena. We're located in the historic Behringer Studios building. It's a beautiful building. Maybe you'll appreciate it as much as I do when you come to visit us. Now, in a survey conducted by Kelton Research, 81% of those surveyed consider their pets to be true members of the family, equal in status to children. And that's from a publication in the magazine Psychology Today. Making your estate plan with your pets in mind, the American Pet Products Association reports that 9% of people with wills and trusts have made provisions for their pets, only 9%, which means that if there are no provisions made, oftentimes those pets are left to their own devices as to what happens next. Why are pet trusts important? Well, unfortunately, when pet owners pass away or become disabled, their pets often end up on the street or in shelters. To keep your pet companions safe, you have to pre-plan. Your pets depend on you. If you haven't provided for the care of your pets and you then become disabled or pass away, who's going to care for your pets? You have to decide on that now. Different documents are intended to provide for pet care, but often produce varying results. When creating an estate plan for the care of your pet, generally we're talking about 3 documents: the powers of attorney, or a will if you choose to use that, or irrevocable trust. If you should become disabled, you want to make sure that your caregivers for the pet are provided with the documents which will give them the authority to act on behalf of your pets, and also maybe to access whatever accounts there may be to care for the pets and their health issues. Now, your intended pet caregivers may not only be caring for your pet, they also may be handling the money that you have left for the pet's care. Oftentimes, our pets have different disabilities, different ailments that require that there be money available for their needs. And if you're worried about a possible disability making you unable to care for your pets, consider naming a trusted person, friend or family member, as your power of attorney, so that when you are disabled, they will be able to go in and do what's necessary for your pet with full authority. Now, there is a difference between wills and trusts when we talk about our pet companions. Wills provide some benefits, but as you'll see when I go through this presentation, trusts seem to provide a lot more. You can provide for your pet's care by either will or trust. To make sure your pet is cared for after you're gone, you can either create a will or trust naming an individual to care for the pet. You can also give the executor of your will or the trustee of your trust the ability to name who that pet caregiver will be. Why is a trust better than a will when planning for a pet? One major drawback in using a will for pet planning is that it can take a long time to execute. It must go through the probate court system. Whenever you have a will, it has to go through the probate court system, which can take months or even years. The problem for your pet is that money will not be readily available to pay for expected expenses, because that will has to be probated, and the process is a slow one. On the other hand, a trust can be implemented immediately, and a caregiver can be subjected to legal consequences if they choose to ignore the terms of the trust that you have created for your pet. In California, pets are just considered personal property. Right? That sounds a little crass, but that's how it is. Whether you employ a will or a trust, you can't make your pet your direct heir. Pets cannot receive assets directly. Since you can't leave money directly to your pet, the best way to assure the pet's care is to set up a trust setting forth the terms of your pet's care. Don't leave the care of your pet undecided. You'll probably want to create a basic budget if you're going to leave money for the pet's caregiving of the pet, pardon me. So you'll want to have something that will deal with the pet's feeding habits. If there's some special needs for the pet, you'll want to take that into consideration. You'll want to provide things like veterinarian information and medical records so that the new pet caregiver won't be left in the dark about these things. You'll want to set forth whatever medical conditions there are that the pet caregiver should be made aware of. It may be that you want to list things like favorite toys or favorite activities, swimming, long hikes, etc., and special quirks. Does the dog get particularly afraid of thunder or doesn't like to be picked up? Those kinds of things. If you have a social media account containing photos and stories about your pet, be sure to share that with the new pet caregiver. Don't assume that someone you know will automatically care for your pet. Once you identify your pet's new caregivers, make sure they'll be happy to take care of your pet. You certainly don't want to drop something like this on someone as a surprise, having assumed that certainly they'll do this for me. Well, oftentimes we have seen that people don't want to do that, and the pet still winds up in a facility somewhere. If you're concerned that the person you designated as your pet caregiver will run through the money and not put it towards your pet's care, you can set up your trust such that the money is doled out on an as-needed basis by your trustee to your pet's caregiver. Additionally, you can plan your trust to name a trust enforcer who will be charged with making sure that the terms of the trust are carried out. And if there's any money remaining in the trust, once your pet dies, you can stipulate that the balance be donated to a pet supporting charity, such as Pasadena Humane. Now, when we talk about estate planning, generally we are putting those pet care provisions in your estate plan. So we're not talking about creating yet another trust for the pet. We're talking about having a sub-trust that will provide for the pet. When we talk about estate planning, we all know that these are difficult times in America. One of the things that we see is that there are lawsuits filed all the time. 15 million lawsuits on average are filed every year. And so of course that's a cumulative effect of lawsuits because they don't go away in a year. Over 1 million families file bankruptcy every year. And the national average for a nursing home stay was $105,000. Over 60 million caregivers provide aid to family members and friends. And there are countless lawsuits filed in our courts every day over defective wills and trusts. Yeah, America has the 3rd highest divorce rate in the world. So these are all the difficulties that we deal with, and they should be motivation for you to consider getting your estate planning in place. And let's not forget the continuing dangers of the coronavirus and other global health issues. Today, we're going to profile a typical couple. Bill and Mary Jones. Bill and Mary have an estate worth about $700,000, including their home. Bill is now retiring. Now, if you're single, widowed, or divorced, married more than once, most everything that I say here will apply to you as well. And you'll be able to easily discern where it does not apply to you. Bill and Mary have 2 children. There's Susan, who is the rock of the family. Mom and dad can always depend on Susan to do the right thing. And then there's the problem child, John. And there seems that many people have a problem child. Now, Bill and Mary have all types of planning options. They could spend everything. Of course, that's always a difficult proposition, trying to see how much you can spend right before you die. You can also die without any will or trust, which means that you die intestate. To die testate means you have planned. To die intestate means you have not. Oftentimes, people will say to me, you know, Bill, I think I'm just going to put everything that I have in my daughter's name. I'm going to put her name on the house. I'm going to put her name on my financial accounts. And that's my estate planning. And my response to that is pretty much standard. I would consider that something you would want to take some time to think about before you do it. And the reason that I say that to them is that whatever problems that child may have, and it doesn't mean that this is a problem child, because things happen to good people too. But whatever difficulties they may run into may become a problem for all of your assets if you do such a thing. So if they get sued, well, your account with their name on it may wind up in the middle of that lawsuit. Or if they have a tax issue or a divorce, all of these things can put your assets in jeopardy. And you certainly don't want to put their names on the house if it's going to create a capital gains tax problem, which it may well. So let's say you bought a house and paid $100,000 for it, and then 10 years later, it's worth $900,000. Well, if you had put your name on the house 9 years later, in this example, that child, if they sell that house, will have to pay capital gains tax from the date that you initially bought the house. So you are creating an unnecessary capital gains tax for your child. Many people will say to me, well, I think I'm just going to create a simple will. I don't have much. I have, I have a house, I have bank accounts, I have an insurance policies, I have a retirement plan, and, I have a simple estate. And of course, I tell them generally, no, what you have is an estate that most people have. I mean, estates differ as to the dollar amount in the estate. I mean, someone may have 2 cars or a bigger house, but generally we all have the same items. So if you talk about just creating a simple will to take care of your estate, I don't think that is the best move for you to do. Because if you have a will, remember, if you have a will, it must go through the probate court process. And that can be a long, drawn out process. And that's, quite frankly, where attorneys make most of their money who work in estate work. So you don't do your family any benefits by not doing proper planning. Some people will say, I'll just create a bare bones living trust. And by that, I mean something that they can find on the internet. And of course, you have to remember, anything that you can find on the internet for free is probably going to be worth what you paid for. Or you can create what we call a family wealth trust, which is a bit more involved. Now, going back to our couple that we are profiling here, Bill is retiring. He had thoughts about what he was going to do in retirement, but the best laid plans often go astray, and Bill winds up having a stroke. Maybe he started his exercise program too soon or whatever it may be, but he's now disabled. He may not even be able to communicate. Now, the impact of medical bills as a cause of bankruptcy is astounding. Over 66% of all bankruptcies are caused by medical bills. And what a lot of people don't see is that a lot of those medical expenses come because the people involved in those bankruptcies don't have long-term care insurance. And what they often did was try to use all the money that they had to be honorable about paying their bills until they were broke. And then they were deemed a person who could file for bankruptcy and often would apply for Medi-Cal. Health insurance. Health insurance does not stop medical bankruptcy. 75% of medical bankruptcy filers had health insurance. And still, because of the extreme cost, they had to file bankruptcy. So when I talk about long-term care expenses, what does that mean? I'm talking about really something that is chronic and ongoing that is not covered by your health insurance. Okay, because your health insurance typically only covers doctor's visits and short stays in the hospital, but it does not cover long-term care medical expenses. And there are only so many ways that you can go to pay for long-term care medical expenses. Now, the different types of care that you can use would include things like in-home care or adult day care or assisted living or nursing home stays. The Genworth survey for 2022, Genworth being a major company in the industry for long-term care insurance, they put out a survey every year. Genworth put these numbers out as to what the cost is, the average cost is in California for these different types of medical care. So I don't need to go through them for you to see that that is extreme and not many people can afford to deal with the burden of those costs. So if you know, and I'll tell you, this is a statistic that has been the same for many years. 7 out of 10 people over the age of 65 will have long-term care health problems. And 40% of that number will have to stay in a facility. So what I'm really saying here is that if you have a an estate plan. And that estate plan does not incorporate what you can do to deal with those long-term care medical bills, knowing that 7 out of 10 of us will have long-term care medical bills. You may not have an adequate estate plan. And so you may want to look at that very closely. And even if you have long-term care insurance, you'll want to take a close look to make sure if it keeps up with the cost of living and how long the policy is in duration. How do you pay for long-term care expenses? Well, if you choose to go this route, you can use your own money and you pay until you have no money. Or you can buy long-term care insurance and hope that you get enough coverage and hope that you qualify. Because of course, after a certain age, or if you have certain disabilities, you may not qualify in the first place. Medicare. I know generally in some vague way, we probably think that Medicare must have a plan to meet these issues. Well, they do, but that plan will only provide for 100 days of care, maximum. And then the burden is back on you. If you're a veteran and you served at least 1 day during wartime, you will be entitled to veterans benefits for your care. But if you don't meet any of those standards, you will find yourself having to avail of Medicaid, which is known as Medi-Cal in the state of California. With Medi-Cal, this is a needs-based program, and you generally must spend all of your assets and be broke before you qualify. But there are other ways that one can qualify. So Bill, as a result of his stroke, is now disabled. And Mary now has unexpected problems. Can she use and control the family's financial accounts and real estate when needed? Because how is she going to pay for Bill's needs? How is she going to maintain the household needs? Bill had one major asset, and that was the IRA that he got through his employer. Also, Bill and Mary have a home that they owned in joint tenancy. If Bill is disabled, conservatorship, which we also refer to as living probate, because probate involves death and conservatorship. Those are two proceedings most held in a probate court. Conservatorships is a process designed to protect those who are mentally or physically disabled, adults who are mentally or physically disabled. Conservatorship is a very difficult process. You want to do all that you can to avoid this situation for yourself. If you've had friends or family members, you know what I mean, what they had to go through. It's humiliating. The court is in control of your life. It's time consuming, and your personal information is disclosed. It's expensive. You're going to have at least 2, sometimes 3 attorneys charging at an hourly rate against your assets, as well as accounting fees and conservator fees. So if you are in a conservatorship, it is by nature a long-term care, a long-term process. So for that long-term care process, you're going to incur these fees, these ongoing attorney's fees and conservator fees and accounting fees until your assets are gone. And remember, a will does not avoid probate. It only guarantees that you must go through the probate court system. What happens in death probate? Okay, we've talked about conservatorship, but what happens in death probate? Death probate is about resolving disputes and paying creditors and having assets appraised and making sure that title to assets is changed from the name of the deceased person to that of the deceased person's beneficiaries. Probate is expensive. What you see on the screen now is what the fees are. It's a percentage fee when you do a probate. and it can become extremely expensive. And that could be avoided, of course, if you had done the planning. In probate, the fees are 4% of the first 100,000, 3% of the next, 2% up to $1 million, and another percent from $1 million to 10 million. But there are also extraordinary services that the court deems are not in the normal realm of a standard probate. And for those, an attorney and the conservator's caregiver, the conservator of the conservatee, pardon me, they both get to charge at an hourly rate for all types of services. The probate is time consuming, it's open to the public, and if you have assets in other states, you'll have to do separate probates in each state. So in our example, let's say Mary lives another 10 years. Mary has Alzheimer's. She is placed into a nursing home, and about half of the elderly end up in a nursing home. Mary is unable to handle her affairs. While going through Mary's papers, Susan finds a power of attorney that Mary had prepared, which she probably did after having experienced the problems she went through in taking care of her husband through his death. Now, she finds this power of attorney and she decides that she wants to take it to an attorney. So Mary consults an elder law attorney. Elder law is something that we do when we are looking to have a plan of action for people as they grow older, to make sure that they do not lose all of their assets as a result of medical expenses. Because we know the medical expenses are going to come in at some level or another. And we want to make sure that if they are too burdensome, that you don't wind up losing everything. Your golden dreams of how life would be are not upended. So Mary speaks to the attorney, and the attorney tells her that we can protect most of your mother's assets if, and the if is whether there is particular language in the power of attorney which would allow that elder law attorney to move assets out of Mary's name, possibly into a Medicaid trust, so that those assets could be protected for Mary, for her use while she's alive, and then ultimately be given to her children. And so the question becomes whether there was an adequate power of attorney that Mary prepared. Well, the reality was that there was no adequate power of attorney, and as a result, Mary had to go through the process of using her own money before she could apply for Medi-Cal. Most estate plans fail for a lot of reasons. Oftentimes, the documents that are done are just canned documents, just forms that are meant to be one size fits all. Estate plans fail also because there is no nursing home protection, no protection for how to deal with those long-term care health issues that we may encounter as we grow older. And plans also fail because people don't understand that you have to title the assets in the name of the trust in order for the trust to be effective. Plans also fail because they don't have provisions in the trust for remarriage protection. And what I mean by that is if Mary decides to remarry, she may decide to commingle her assets with a new spouse. And then what happens if she dies? Well, you can kind of see the picture there. The new spouse winds up with those assets and the children are left out in the cold. Plans also fail because there's insufficient protection for the children. So our children differ. I mean, there will be children who have a great sense of responsibility and you know that they'll know the right thing to do, and then other children who will not, or children who can be easily influenced as to what happens with the assets. What you need to consider there is how to create sub-trusts that speak to the needs of each child. Okay. Plans also fail because people don't keep you up to date about the changes in the law. Most people who have had their trust done, and I'm sure many of the people on this call would agree with me, you have the plan done, but you never hear from the attorney again. Well, that's not really a good thing, because the laws do change. The California Trust and Estate section for the state bar is always setting out information about new changes in legislation and in case law. And if those kinds of changes in the law affect your estate plans, you need to be made aware of that. What is an estate plan? And how does it work? Well, an estate plan is a grouping of a number of different documents that are meant to work together for your benefit. So there's a revocable trust into which you will title most of your assets and say who will be in charge of your assets and your affairs, and list who the beneficiaries will be. There's a document called a pour-over will, which is unlike the typical will that we often think of that says, I hereby leave my earthly possessions to this person or that person. A pour-over will is used only in conjunction with the trust. And the term pour over comes from the fact that it is meant to protect those assets which you may not have put into your trust, though you should have. And it allows for your representative to go into court and say that this is an asset which should not go through probate, and we'd like to pour it over into the trust. Then there are the powers of attorney. Your powers of attorney for healthcare, and of course, that's pretty self-evident. You're going to name someone who will deal with doctors and hospitals on your behalf. And then there's the other power of attorney, which has different names. Sometimes people refer to it as a durable power of attorney or a financial or property power of attorney. But the final analysis is that that power of attorney is meant to handle your financial accounts and other things, but it will make sure that that person is authorized to sign checks on your behalf and sign agreements on your behalf, make sure that the utilities continue to be paid and the mortgage is paid when you are unable to do so for yourself. Also, please note that with powers of attorney, they do terminate when a person dies. For those of you who are married, we do a community property agreement, which is meant to make sure that if you own real estate, that the $250,000 of capital gains tax exclusion that each co-owner of the property has will not disappear when one person dies. So generally, if you have property in joint tenancy means that the property is meant to go to the surviving person when the other owner dies, which means that that $250,000 exclusion that was used for the person who died goes away. So we have an agreement that we would have prepared for you by which you'll be able to save the entire $500,000 of capital gains tax exclusion. So let's give Bill and Mary a quick do-over. Bill is going to have the same plans about exercising and planning vacations and retirement. This time, instead of a will, he wants to create a living trust, and he will look into nursing home planning. Bill has that stroke as he did before. And one thing you should remember is that estate plans are not like commodities. Of course, if you go and buy a 5-pound bag of C&H sugar at one market, you expect it to be the same at another. The same with a Ford automobile or kitchen utensils. Those are commodities. Estate plans differ widely, and you need to have one that's meant to protect your needs. Now, with the trust, and Bill having encountered this stroke again, Mary doesn't have to go hand in glove to go to banks and IRA administrators to have them grant her authority to access the assets. Because remember, with an IRA that Bill had, that IRA is an asset that Bill owned. Mary was just a beneficiary. With the house, that was an asset that they owned in joint tenancy, and Mary was could not do anything if Bill was still alive in terms of selling it. After Bill dies, Ralph, the next door neighbor, may come around and display an interest in Mary. Question is it for love or money? Maybe Ralph has had some difficulties that he's encountered in his life financially, and you just want to make sure that his intentions are sound, right? So what we can do for Mary, when in this estate plan that she and Bill do together with the trust, is that we can put prenuptial language into that trust. And what that language is meant to do is to protect the assets that Bill and Mary have created together, such that if Mary decides to marry Ralph and she dies, Ralph will not be able to take those assets, because Mary, prior to that marriage, Mary will be required to say to Ralph, you know, we can't commingle the assets that I had prior to our marriage. And here's the language in the trust, I can't do it. So that's what that is about. Because what happens oftentimes is that people just marry, they commingle assets with the new spouse. And as a result of that, the children are unintentionally disinherited. So Bill's had a stroke, Mary now has Alzheimer's, but that's okay, because this time around, she has named her daughter Susan, her responsible daughter, to take care of her affairs, to manage the trust. There won't be any court proceedings or loss of control or delays or expenses that you might have if you didn't have an estate plan in place. There won't be any conservatorship needs, because you will have named who your caregivers are in your trust. Now, upon the death of both Bill and Mary, will their estates have to go into probate? Well, the answer is no, because what the trust is about is making sure that all the assets are put into the trust. The trust is the owner of title on those assets. And what probate is about is the death of people. And because your assets are in a trust, you don't go through probate. There won't be any need for death probate. And with a well-done estate plan, you will have the ability to create a plan that will provide a wonderfully intangible gift to your family that they might not otherwise get. I'm talking about creating a plan that will incorporate the family's history, so that in addition to the money that they get, they'll get this history, so that will benefit the children and the grandchildren, the great-grandchildren, the extended family for that matter, because that's a story that they weren't going to get anywhere else. When you do a well-prepared estate plan, there are certain sub-trusts that come with that type of planning. And I won't go through the particulars of those in the interest of time, but there are all kinds of sub-trusts that you can use for creating benefits for grandchildren, or divorce protection for your children, or special needs children. All of these kinds of things can be done. Or if you have blended families, these kinds of things can be done to protect everybody involved. Not all living trusts are equal. Some have Medicaid planning and some don't. Now, charitable giving. There are 5 primary methods of planned giving. You will want to make bequests to the Pasadena Humane Society through your estate plan. You can also create gift annuities that can benefit charities, or you can name Pasadena Humane as a life insurance beneficiary. You might also want to consider naming Pasadena Humane as a retirement account beneficiary, or through the donation of real estate or other assets directly through your trust to Pasadena Humane. I would ask that you consider Pasadena Humane as a worthy beneficiary of your estate plan. Remember your own pet in your planning, but also support Pasadena Humane's ongoing mission to bring aid and comfort to abandoned pets everywhere. So question is, exactly when do you intend to create a plan? There's been so much happening in the last few years. There's certainly been enough motivation to get that estate plan in place, if ever. So consider getting yours done right away, and don't forget Pasadena Humane into planning. Thank you very much.
Thank you, Bill, so much for that very, very interesting presentation. And I hope that everyone here today has taken something away from it. I would like to open the floor now to questions. You can either use the Q&A function in Zoom, or you can put your question in a chat. And so if anybody has any questions about what Bill's presented, please don't hesitate to ask right now. My and Bill's contact information were shown on the slides. We are both available. If anyone would like to contact us afterwards for a consultation with Bill, or if you would like to learn more about how a planned gift can help the animals at Pasadena Humane, there's a variety of ways you can make such a gift. And I would be very happy to meet with you, talk to you over the phone, do a Zoom thing, and answer those questions that you have. And we will, oh yeah, I see the slide right now. We also have a guide to pet trusts that the Hayes Law Firm helped put together for us. And I'd be happy to send that out to anybody who would like that, along with our own estate planning guide, to anyone who requests it. We will be sending out the recording of this webinar to everyone in attendance and to those who were not able to make it today. So yeah, just don't hesitate to reach out afterwards and follow up with us if there's anything more that we can do for you. Does anybody have any questions? Anything about either planned giving or even the Pasadena Humane Society? Okay, looks like we have one. Oh, Diane, hi, yes. So if this is an excellent question. If you do include Pasadena Humane in your estate plan, you become a member of our 1903 Society of Planned Giving Donors. And one of the benefits of that membership is our pet guardianship program. Now, Bill had mentioned early in the presentation, and I say this as well, we always encourage people to find a trusted friend or family member to be the caregiver of any pets they may leave behind, if anything should happen, if you should die or become disabled even. But we know that not everyone is able to do this, so that's where our pet guardianship program comes in. If you include us in your plan, then, and you don't have anyone to care for those pets that you may leave behind, the shelter can step in and care and rehome those pets. I do have a questionnaire form that I can send you, and it's asks for information about the pets that you have, and it's just a way to help us find the best home if your animal should come to us. And it asks for medical information, behavioral questions, what you even feed the dog, favorite toys, things like that. And then it just gives our staff a better understanding of your animal, and we can try to find the best home for it. Does anybody else have any other questions? I will note that if you are considering including Pasadena Humane in your plan, you can include us in your will. You can include us as a beneficiary of an IRA or a beneficiary of a life insurance policy. You could leave real estate to us. There's a variety of ways. So it doesn't always have to be in your trust to receive a certain dollar amount or a percentage. You can do that, of course, but there's also other vehicles that you can choose as well.
Mia, I did see someone by the name of Katrina raise her hand, but it disappeared.
Oh, Katrina, are you still there? Do you have a question? Okay, let's see. Hi, Katrina. Oh, you're welcome, Katrina. I'm glad you enjoyed the presentation. And I hope everyone else did as well. And we still have some time if anybody has any other questions. You're welcome, Suzanne. And again, we will be sending out the recording afterwards. So if you have a chance to review it, and if any questions occur to you later on, just don't hesitate to reach out to Bill or myself. Well, it doesn't look like we have any other queries out there. So I would just, so we finished a little bit early, so you are now free to go about and enjoy the rest of your day. And again, on behalf of Pasadena Humane, thank you very, very much for joining us today. I'd like to thank our presenter, Bill, for such a wonderful presentation.
Thank you.
Okay, thank you, Bill. Thank you, everybody. Enjoy the rest of your day. Enjoy your Friday and your weekend.
Bye.
Bye-bye.